Hi, my name is Dr. Ihuoma Ilobinso of the Faculty of Law, University of Lagos, specifically the Department of Commercial and Industrial Law. So I am a lecturer, one of the lecturers that take contract law here at the faculty. And for today's recording, we are going to be discussing damages, which is one of the common law remedies for parties who have suffered loss. So what is damages? When we talk about damages, what do we mean? Damages is simply said a monetary compensation that is given to a party who has suffered loss. So for a party who has suffered loss, there's been a breach of contract and the person has suffered loss. Once it's established that that person has suffered loss, then that person is entitled to damages. But then damages is not the only remedy that is available to parties when there is a breach. When there is a breach of contract, we have the common law remedies, we have the equitable remedies. The common law remedies are as of right. Once it's been established that there has been a breach of contract, then a party is entitled to damages. But then we also have the equitable remedies, which we will not be discussing in this recording. So what is damages? When we talk about damages simply means a monetary compensation that is given to a party who has suffered a loss due to a breach of contract. And as I said, it's a common law remedy, so it's as of right. A party, once it's been established that that party has suffered a loss, then the party is entitled to damages. The courts would usually resort to damages as the very first type of remedy for a party. So it's a traditional remedy in contract law. Before the court decides to look at other forms of remedies, it needs to ascertain, that the monetary compensation would not be sufficient to be able to compensate the party who has suffered the loss adequately. In contract law, the aim of damages is different, from the aim of damages in torts. In contract law, the aim of damages is to put the party in the position that that party would have been if that contract had been performed according to the terms of the contract. But this is different from torts. And even when it has to do with misrepresentation, fraudulent and negligent misrepresentation. So in fraudulent and negligent misrepresentation or in torts, the aim is not to put the party in the position they would have been if the contract had been performed, but rather to put the party in the position they were before the contract was entered into or before the contract was made. So the aim of damages is not to punish the party who caused the breach, right? It's not to punish the party, so it's not punitive in contract law. The aim is to compensate the party who was injured or who suffered the loss. The aim is not to enrich the party who suffered the loss, right? But to compensate him for the particular loss that he suffered. So before the court can be able to grant a party, this award of damages, there are certain things that the court has to ascertain first. First, was there a breach? Second, did the breach, result to a loss? Did that party suffer a loss? So the aim is to compensate that party for the loss that they have suffered. And did the party even take some steps in order to mitigate their breach, in their loss, right? Because a party who has suffered a loss has the responsibility to make sure that they mitigate the loss that they have suffered. So what happens is that the court is trying to find a balance between protecting the party who has suffered the loss, compensating that party fairly, and, ensuring that they are not punishing the other party unjustly, that the punishment that is not excessive or unjust. So to be able to do this, the court has come up with basically 3 rules. There could be more, but these are the ones that are very important. These 3 rules or these 3 principles aim to be able to create that balance in order to determine how much a party is entitled to, whether the party is even entitled to damages or not in the first place. So these rules are the remoteness doctrine, causation, and mitigation. So let's start with the first one. What does causation mean? It means that for a party to be entitled to any damages at all, there must have been a breach of contract. And that breach of contract must have resulted to a loss, because there could be a breach of contract and there will be no loss. Let me give you an example. If A enters into a contract with B to buy and sell this system, right, and A promised to sell to B this laptop for 500,000 naira, and B agreed. So the contract had been formed. There was offer, acceptance, and consideration, and all the other elements of a valid contract. So the contract had been formed. But then, when it was time to sell, B refused to take delivery of the goods. B refused to make payments, and therefore that B had breached the contract. That is a loss, right? But then A immediately found another buyer who bought the laptop for 500,000 naira, which was what was agreed between A and B. So you see that there was a breach of contract, but there was no loss that's been suffered, because the goods have been bought for the exact amount. So in such a case, the court is not going to grant you excessive damages. What the court would do is grant what we refer to as nominal damages. And what are nominal damages? They are just very small amounts to be able to, compensate, to provide you with some sort of damages. So before the court can grant damages, the first rule, as I said, is causation. Was there causation? Did the breach result to a loss? If the answer is yes, then that would be one of the rules in which the court will determine whether to grant you damages or not, and the amount of damages to grant. If the answer is that the breach did not result to a loss, then the court will probably grant you nominal damages. So what types of losses are recoverable? Is it all types of losses, that happens that the innocent party or the injured party is entitled to damages? The answer is no. In contract law, we have the pecuniary losses and we have the non-pecuniary losses. The pecuniary losses are the ones that are quantifiable in money, or the economic losses. And the non-pecuniary losses are things like feelings, hurt feelings, the feeling of distress, disappointment, mental distress, loss of enjoyment. So generally in contract law, non-pecuniary losses are not recoverable except where the primary purpose of the contract, of that agreement, is provision of pleasure or leisure. And you can see in the case of Jarvis and Swantos Limited and Roxley Electronics and Construction against Fawcett. So the second principle is remoteness. What type of losses would the court be willing to grant damages for? When we have consequential losses, the type of losses that might not be directly as a consequence of a breach, the court would usually be wary to grant damages for that, because it will consider it unfair for a defaulting party to be exposed, compensate the other party, the injured party, for things that they did not anticipate, for losses that resulted from the breach of contract, which they knew, okay, I breached a contract. I was supposed to take you from your house, your residence, to school, and I did not do that. For instance, an Uber driver who was supposed to had entered into a contract with you to drive you from one point to another. He did not drive you to that point. He has breached the contract. He's aware of it, and he's probably ready to compensate you. But then the compensation you're asking for is for 500,000 naira or for 5 million, based on the fact that because he breached the contract, you ended up missing an interview where you were going to be awarded a scholarship, and a 5 million naira scholarship. So you are asking that he should pay for the 5 million. You see that in such a case, that is a consequential loss. He did not expect, or he would not have anticipated, that the fact that he did not that he breached the contract would result in him having to suffer that type of liability, with respect to remedies. So in such a case, the court will be very wary to grant those types of damages. And for that, you should see Hadley and Baxendale. What happened in that case was that a transporter was supposed to transport a crankshaft for repairs, And he took his time. He wasn't aware that there was a need to return the crankshaft on time, and due to that, the plaintiff had a loss of business. He lost a lot of business. He lost a lot of money. So he brought an action in court. And the question before the court was that, was he aware? Was the loss a direct consequence of the breach, or was it too remote, for it to be reasonably foreseeable? So was that loss foreseeable? Could the defender had foreseen that, the breach of this contract would lead to this type of loss? So was there sufficient connection between the breach and the loss? So for the court to be able to grant you, damages, there has to be some sort of connection. So what the court has done is that in such a situation, the court would usually ask, did the loss flow naturally according to the usual course of things from the breach? And the second one is that where it does not flow naturally from the breach, then they would only be recoverable if the loss is one that could have been foreseen. So the first question that the court would ask, according to Hadley and Baxendale, is that did the breach flow naturally? Did the loss flow naturally from the breach? If the answer is yes, then that sorts it out. But if the answer is no, then the next question is, was it reasonably foreseeable? Could the other party had contemplated that breaching this contract to result to this loss? And in the case of Hadley and Baxendale, as I said, the court held that it wasn't reasonably foreseeable. He could not have foreseen that his inability to perform his contract according to the terms of the contract, would lead to this type of loss. And the final rule is with respect to mitigation. As I said earlier, the law imposes this responsibility on the injured party, to take steps, to take some certain reasonable steps to mitigate the loss caused by the breach of the contract. So if the innocent party did not take reasonable steps to mitigate that loss, then he should not expect to receive a humongous amount of damages. And you can see that in British Westinghouse Electric and Manufacturing Company against Underground Electric Railway Company of London. Other classifications of damages, damages can be broadly classified too into special and general and special damages, and it can also be classified into liquidated damages and unliquidated damages. So what are general damages? The general damages are simply those damages that the court would imply in every breach, in every violation, of the rights of the parties. So what happens is that if the loss is the type that flows naturally from the breach, from the breach of the contract, then the court can on its own, grant damages without needing them to prove and that they actually suffered this specific type of loss or not. This is different from special damages, where these are damages that are specific and peculiar. They don't flow naturally. So once you are claiming special damages, you need to be able to prove, to provide credible evidence that these are the things that you suffered. These are the losses that you suffered. For instance, an example of a special damage is where you say, I suffered loss of business. You need to be able to prove that on so and so days usually work, right? And when you work, you earn, let's say, 1 million a day or 300,000 every day. So you need to be able to prove it. You need to be able to provide evidence to show, or the fact that, okay, when you breached the contract, I had to travel and I had to lodge in a hotel and I had to feed myself. So you need to provide evidence of that, maybe in the form of receipts. I traveled, I took a flight. This is how much it cost. I lodged in a hotel. This is how much it cost. I ate. This is how much it cost. So for special damages, you need to be able to provide evidence to be able to prove it. So the general rule is that parties are not, in contract law, maybe in torts you can do that, but in contract law you're not allowed to seek damages from the two heads right? So you're not allowed to seek damages under general and special, but then in practice it's done all the time. Parties who have suffered loss can usually seek damages under special damages and under general damages. So general damages, the court awards whatever it feels is reasonable and is what the party should, what is good enough to compensate the party. And then the special damages. But the rule is that double compensation is not the aim of damages in contract law. Remember that the aim is not to punish or to enrich, right? The aim is to just provide compensation. So when parties seek their damages under these two different heads, is almost extravagant, is almost a whole lot, right? So the rule, and the Supreme Court in numerous cases have actually held that a party is erroneous in law for parties to seek general damages and also seek special damages, and there are a number of cases to support that, especially the case of British Airways against Atoyebi. It's a 2014 case. But then courts in practice have continued to do this, and this is quite erroneous. So thank you very much for your attention. So this is a conclusion of what we have discussed, damages, right? And for the next recording, we'll be discussing specific performance and other types of remedies. So thank you for listening. Please subscribe to the faculty's channel and also click the notification button so that you would get notified whenever we drop a new video. Thank you.